The House Judiciary Committee chamber pulsed with quiet tension. Representative Ted Lieu of California leaned forward toward his microphone, his expression a rare blend of irritation and disbelief. For nearly 20 minutes, Representative Jasmine Crockett had been methodically dismantling his proposed judicial reform bill, countering each provision with constitutional precision, historical precedent, and courtroom-tested authority. "Representative Crockett," Lieu began, his tone sharp enough to slice through the murmurs in the room. "Before we continue this debate on judicial qualifications, I think it's important to establish your credentials in this area. You've critiqued my proposal at length. But what specific experience do you have evaluating judicial nominees that qualifies you to dismiss the work of those who've dedicated their careers to this field?" The hearing room went still. Committee members exchanged glances, some raising eyebrows at the boldness of his challenge, particularly since it came from a colleague within the same party. Reporters leaned forward in unison, sensing a headline in the making. The air grew dense, every shuffle of paper and every breath amplified. Crockett sat motionless. For 3 long seconds she simply looked at Lieu, her face unreadable. Then, without breaking eye contact, she reached for her microphone and spoke with a calm, deliberate authority that immediately seized the room. "Congressman Lieu," she said evenly, her voice resonant but restrained, "before I joined this body, I didn't just appear before the kinds of judges your bill proposes to evaluate. I served on the State Judicial Nomination Commission for 7 years. During that time, I personally vetted 118 judicial candidates, applying the very constitutional standards your legislation attempts to reinterpret." She paused only briefly before continuing, her tone unwavering. "Would you like me to begin by explaining which provisions of your bill conflict with Article 3, jurisprudence, or shall we start with the Davidson precedent that your staff seems to have overlooked?" Lieu's confident expression faltered. A flicker of discomfort crossed his face as the room erupted in a low hum of whispers. Even seasoned political reporters froze mid-keystroke. Committee members straightened, suddenly alert, sensing they were witnessing not a routine debate, but a defining exchange between 2 legal heavyweights. Before diving into this extraordinary clash between 2 rising Democratic stars, commentators would later describe this as a rare moment of constitutional clarity amid political theater. Representative Jasmine Crockett had earned her reputation in Congress the hard way, through meticulous work, not media soundbites. A graduate of the University of Houston Law Center, she had practiced civil rights law for 15 years before stepping into politics. Her background wasn't theoretical. She had tried over 70 federal cases, argued before 3 circuit courts of appeal, and built specialized expertise in constitutional law and judicial accountability. Before her election to Congress, Crockett had served on the Texas Judicial Nomination Commission, where she assessed judicial candidates based on legal acumen, temperament, and constitutional philosophy. That experience gave her a rare, first-hand understanding of how judicial temperament and philosophy could shape the lives of ordinary citizens. "The judiciary isn't abstract theory for me," she had told supporters during her first campaign. "I've spent years inside those courtrooms, watching how judicial philosophy determines whether justice is delayed or denied." At 42, Crockett approached her role in Congress with the same unflinching rigor she once brought to the courtroom. She was known for reading every line of proposed legislation herself, often spotting constitutional vulnerabilities others, relying on staff summaries, completely missed. Representative Ted Lieu, by contrast, was already a fixture in Washington, one of the chamber's most respected voices on technology, cybersecurity, and government ethics. A Stanford graduate and former Air Force JAG officer, he had prosecuted military cases before turning to politics. His background lent his arguments a certain procedural precision and analytical confidence. The Judicial Evaluation Act represented his most ambitious legislative endeavor yet. The bill aimed to create new performance metrics for federal judges, efficiency ratings, reversal statistics, and procedural compliance scores, to be published for public review. Lieu's message was simple. "Transparency breeds accountability. We hold every branch of government accountable," he had argued when introducing the bill. The judiciary should not be exempt. These evaluations would strengthen, not weaken, public trust. The idea resonated with many who viewed the judicial system as opaque and unaccountable. But constitutional scholars and jurists warned that such oversight risked political encroachment on judicial independence. The very principle the founders sought to preserve, that philosophical divide, was at the heart of today's hearing. Was judicial accountability a constitutional duty or a constitutional danger? The hearing itself had begun uneventfully. Chairman Gerald Nodler gavelled the committee to order precisely at 10 a.m. Today's session will consider H.R. 4217, the Judicial Evaluation Act, he announced. Representative Lieu, as the bill's primary sponsor, you are recognized for 15 minutes. Lieu approached the podium with the confidence of a trial lawyer. For 15 minutes, he laid out his case, methodically and eloquently. Slides appeared behind him, displaying statistics that showed vast disparities in case resolution times among federal judges. This legislation, he explained, establishes objective metrics, case clearance rates, reversal percentages, procedural compliance, to assess the administrative performance of federal judges. The results would be published quarterly, ensuring transparency without infringing on judicial independence. He concluded with a line designed to preempt criticism. Some will claim this bill threatens judicial autonomy. It does not. Judges would retain complete decisional independence. We merely evaluate administrative performance. The Constitution's system of checks and balances demands oversight from each branch, including ours. Several members nodded approvingly. Lieu's presentation was polished, persuasive, and politically safe, a call for accountability framed as a defense of democracy. Chairman Nodler thanked him and opened the floor for questions. Representative Crockett, he said, you are recognized. Crockett leaned forward, her tone courteous but razor-sharp. Thank you. Mr. Chairman, she glanced at Lieu. Congressman Lieu, I appreciate your commitment to improving judicial performance, but I'd like to discuss the constitutional foundations of your proposal. She adjusted her microphone slightly. The Constitution safeguards judicial independence through two structural protections: lifetime, tenure, and salary security. Would you agree these were designed specifically to shield judges from external influence? Lieu nodded. Yes. But those protections address decisional independence, not administrative accountability. Our bill doesn't affect tenure or pay. Crockett inclined her head. Let's examine that distinction carefully then. Her voice remained calm, but each word carried weight. Section 204 of your bill mandates quarterly efficiency ratings to be published and sent to the Judicial Conference. Correct? Yes, for transparency, Lieu confirmed. And Section 301, she continued, instructs the Administrative Office of the U.S. Courts to use those evaluations when distributing resources to courts and judges. Is that correct? Lieu hesitated. Yes, only to ensure more efficient resource allocation. So, judges with lower efficiency ratings could receive fewer resources, Crockett summarized coolly. Would you agree that constitutes a form of administrative penalty? Lieu's brow furrowed. The impact would be minimal, purely procedural. But the Constitution, Crockett interjected gently, does not recognize distinctions between minor and major pressures when it comes to the judiciary's independence. She leaned slightly closer to her microphone, her voice firm but measured. In 1982, the Supreme Court addressed this exact issue in Northern Pipeline Construction Commodivers Marathon Pipeline Co., stating explicitly that even indirect coercive pressures on judicial conduct raise serious constitutional concerns. She opened a legal reference book. Justice Brennan wrote that our Constitution unambiguously ensconces the judiciary as a branch of government, insulated from direct or indirect administrative control by the political branches. Your bill appears to establish precisely the type of indirect administrative control Justice Brennan warned against. Murmurs spread through the committee room. Lieu, clearly unprepared for such specific presidential challenges, attempted to direct. Representative Crockett, these are administrative measures only. The bill explicitly states it doesn't affect judicial decision-making. With respect, Congressman, stating something doesn't make it so, Crockett replied in Mista versus United States. The court emphasized that the practical consequences of legislation matter more than its stated intentions when assessing separation of powers concerns. She turned to Section 408 of the bill. This provision requires judges to report the time spent on each case type and justification for cases exceeding median resolution times. But different cases require different approaches. A complex constitutional question might legitimately require more deliberation than a straightforward statutory interpretation. Wouldn't this reporting requirement create pressure to prioritize speed over thorough constitutional analysis? Lieu appeared increasingly uncomfortable. The reporting simply creates transparency. Judges can explain their reasoning. Having to explain why you're taking necessary time to consider constitutional implications creates the exact pressure the framers sought to prevent, Crockett countered. Alexander Hamilton addressed this specifically in Federalist 78, noting that judicial independence requires freedom from both direct control and subtle influence. The bold Deppen dynamic in the room had shifted noticeably. What began as a routine policy discussion had transformed into a constitutional masterclass, with Crockett methodically identifying specific legal vulnerabilities in Lieu's proposal. Lieu attempted to regain momentum. Representative Crockett, many scholars support increased judicial accountability. I'm not questioning accountability, but constitutional methods, Crockett clarified. The Constitution already provides mechanisms for judicial accountability: appellate review, the impeachment power, and public opinions. Your bill creates extra constitutional mechanisms that blur the separation of powers. She held up the text of the bill. Section 512 empowers the Congressional Research Service to audit judicial opinions for procedural irregularities. This effectively places a legislative agency in the position of evaluating judicial reasoning. How does this not violate the basic constitutional principle that Congress may not sit in review of judicial decisions? The question hung in the air. Committee members leaned forward, recognizing they were witnessing not merely partisan disagreement, but a substantive constitutional debate between two knowledgeable attorneys. Lieu, visibly frustrated by Crockett's precise constitutional critique, made a tactical error. Rather than addressing her specific points, he questioned her authority to raise them. Representative Crockett, he said, his voice betraying unusual frustration. Before we continue this debate on judicial qualifications, I think it's important to establish your own credentials in this area. You've critiqued my proposal extensively, but what specific experience do you have evaluating judicial nominees that qualifies you to dismiss the work of those who've spent decades in this field? The room fell silent at the unexpected personal challenge. Several committee members appeared startled by the direct questioning of a colleague's qualifications, particularly since both representatives belonged to the same party. Crockett's response, calm, measured, and devastatingly specific, would become the hearing's defining moment. Congressman Lieu, she began, before joining Congress, I not only practiced before the very judges your bill would evaluate, but I served on the State Judicial Nomination Commission for 7 years, where I personally vetted 118 judicial candidates using the exact constitutional standards your legislation incorrectly reinterprets. Would you like me to elaborate on which specific provisions of your bill contradict Article 3 jurisprudence? Or shall we first address the Davidson precedent that your staff appears to have overlooked? The response silenced the room. Lieu's attempt to question Crockett's expertise had backfired dramatically, revealing not only her substantial qualifications, but also suggesting his team had missed relevant legal precedent. Chairman Nodler, recognizing the significance of the exchange, intervened. I believe Representative Crockett has established her credentials in this area. Please continue with substantive questions about the legislation. As questioning resumed, Crockett shifted from defense to a methodical dismantling of the bill's constitutional foundations. Her approach wasn't theatrical or personal. It was the measured evidence-based analysis of an experienced constitutional attorney identifying specific legal vulnerabilities. Congressman Lieu, she continued, I'd like to focus on Section 615, which authorizes congressional review of judges whose efficiency ratings fall below certain thresholds. This provision creates precisely the kind of congressional pressure on judicial function that Madison warned against in Federalist 47. She opened a constitutional reference text. Madison wrote that the accumulation of all powers, legislative, executive, and judiciary in the same hands may justly be pronounced the very definition of tyranny. Your bill effectively places judicial performance evaluation under legislative control, blurring this essential separation. Lieu attempted to recover. These evaluations don't control judicial decisions. They simply measure efficiency. Let me ask you directly, Crockett replied. If a judge is deliberating a complex constitutional case involving congressional power and knows that taking additional time will trigger a congressional efficiency review under Section 615, do you believe that knowledge might influence the judge's allocation of time and resources to that case? Lieu hesitated. That's speculative. It's precisely the constitutional concern that Justice O'Connor addressed in her concurrence in Commodity Futures Trading Commission versus Shore. Crockett countered immediately. She wrote that the separation of powers is a structural safeguard, rather than a remedy to be applied only when specific harm or risk of specific harm can be identified. She turned to another section. Your bill also empowers the administrative office, which reports to Congress, to issue procedural recommendations to judges with below-average efficiency ratings. This directly contradicts the Supreme Court's holding in Plout versus Tape Spendthrift Farm that Congress cannot prescribe rules of decision to the Judicial Department in cases pending before it. The technical precision of Crockett's analysis had transformed the hearing. Rather than partisan talking points, She was providing a comprehensive constitutional evaluation that committee members from both parties were following with growing interest. Representative Lieu interjected, appearing increasingly defensive. Many of these concerns were addressed during the drafting process. Section 7(1)(02) specifically states that nothing in this act shall be construed to impair judicial independence. A savings clause doesn't cure constitutional defects, Crockett responded. The Supreme Court made this clear in INS v. Chata, stating that constitutional concerns cannot be erased by a simple legislative declaration that the statute doesn't do what it clearly does. She continued methodically through the bill, identifying 7 specific provisions that raised serious constitutional questions under established Supreme Court precedent. Her analysis wasn't ideological. It was a lawyer's careful examination of constitutional boundaries between the branches. Sensing the shift in the room, Lieu attempted a different approach. Representative Crockett, do you oppose all efforts to improve judicial accountability? The American people deserve to know how their courts are functioning. I support constitutional accountability mechanisms. Crockett clarified. Congress has legitimate oversight tools, confirmation hearings, impeachment power, jurisdiction regulation, and budget authority. What we cannot constitutionally do is establish ongoing evaluation systems that create pressure on judicial decision-making, whether direct or indirect. She turned to address the committee broadly. The fundamental constitutional problem with this bill isn't its goal, but its mechanism. By establishing congressional evaluation of judicial performance, it creates precisely the pressure on judicial independence that the Constitution was designed to prevent. Crockett then offered an alternative approach. If we genuinely seek improvement in judicial administration, the Constitution provides a clear path. Work collaboratively with the Judicial Conference, which the Constitution empowers to manage the court's internal affairs. The current bill bypasses this constitutional structure by imposing external congressional metrics on judicial function. The contrast between Lieu's increasingly defensive responses and Crockett's composed constitutional analysis had become the defining narrative of the hearing. What began as routine committee business had evolved into a masterclass on separation of powers jurisprudence. Chairman Nadler, recognizing the significance of the exchange, extended Crockett's questioning time. The committee would benefit from completing this constitutional analysis. Representative Crockett, please continue. Crockett nodded. Thank you, Mr. Chairman. I'll conclude with perhaps the most fundamental constitutional concern. Article 3 vests the judicial power of the United States in the Supreme Court and such inferior courts as Congress may establish. The power to evaluate how that judicial power is exercised, including efficiency, procedure, and case management, is itself an element of judicial power that cannot constitutionally be transferred to the legislative branch. She closed her reference materials deliberately. James Madison warned in Federalist 48 that a mere demarcation on parchment of the constitutional limits of the several departments is not a sufficient guard against those encroachments which lead to a tyrannical concentration of all the powers of government in the same hands. This bill, however well-intentioned, represents precisely the kind of encroachment Madison cautioned against. The room fell silent as Crockett concluded. Several committee members were visibly reconsidering their positions based on the constitutional concerns she had raised. The chairman turned to Lieu. Would you like to respond to these constitutional concerns? Lieu, recognizing the shift in momentum, adopted a more conciliatory tone. I appreciate Representative Crockett's thorough constitutional analysis. While I believe many of these concerns could be addressed through amendments, I acknowledge that separation of powers questions deserve careful consideration. I would welcome the opportunity to work with Representative Crockett to refine the bill's approach. This tactical retreat, acknowledging Crockett's constitutional expertise rather than continuing to challenge, it represented a significant shift from his earlier confrontational approach. The committee members recognized this subtle concession, with several nodding approvingly at the more collaborative tone. Chairman Nadler summarized the exchange. This committee has witnessed an exemplary demonstration of constitutional analysis today. It's precisely this kind of substantive evaluation that should inform our legislative process. As the hearing concluded, legal correspondents who had been furiously taking notes approached Crockett for additional comments. Her response maintained the same professional focus that had characterized her questioning. This isn't about politics or personalities. It's about the constitutional boundaries that protect judicial independence. I look forward to working with Congressman Lieu to develop accountability measures that respect those boundaries. What began as Lieu's attempt to question Crockett's credentials had culminated in widespread recognition of her constitutional expertise and a public commitment to incorporate her concerns into the legislation. For observers of congressional procedure, The exchange represented that increasingly rare phenomenon in modern politics, a substantive debate that actually improved the legislative process. By evening, the exchange between Representatives Crockett and Lieu had transcended routine committee business to become a significant moment in contemporary constitutional discourse. Legal blogs and news outlets highlighted the confrontation not for its political drama, but for its substantive constitutional content. The Washington Post's legal affairs correspondent captured the general sentiment. What made today's Judiciary Committee hearing extraordinary wasn't political theater, but constitutional substance. Representative Crockett's analysis represented that increasingly rare congressional phenomenon, expertise-driven oversight focused on constitutional boundaries rather than partisan advantage. Scott's blog published a detailed analysis titled The Crockett-Lieu Exchange, a separation of powers masterclass, noting that scholars of constitutional law will likely reference this hearing for years to come as an example of how congressional debate can and should engage with fundamental constitutional principles. For Lieu, the aftermath required careful navigation. Initially, his staff attempted to characterize the exchange as a healthy debate between colleagues with different perspectives. This framing gained little traction as more people watched the full confrontation and recognized the principle watched directly. Precision of Crockett's constitutional critique. 3 days after the hearing, Lieu demonstrated political acumen by embracing rather than resisting the constitutional concerns Crockett had raised. He issued a statement announcing that after consulting with constitutional scholars and considering Representative Crockett's thoughtful analysis, I will be introducing a significantly revised version of the Judicial Evaluation Act that addresses separation of powers concerns while maintaining our commitment to judicial accountability. This approach, acknowledging the rather the validity of Crockett's critique rather than doubling down on his original position, earned Lieu praise for intellectual honesty. A senior legal correspondent noted, in an era when politicians rarely admit a consideration, Representative Lieu's willingness to substantively revise his legislation based on constitutional concerns demonstrates genuine commitment to constitutional governance. For Crockett, the aftermath brought heightened attention to her constitutional expertise. Law schools requested permission to use video of the exchange in classes on separation of powers and constitutional structure. The American Constitution Society and Federalist Society, ideological opposites in the legal world, both invited her to address their annual conventions on judicial independence. The substantive impact extended beyond personal recognition. 2 weeks after the hearing, the Judicial Conference of the United States, the ADD, constitutional body responsible for judicial administration, announced the formation of a special committee on judicial efficiency and constitutional independence, explicitly referencing the Judiciary Committee hearing as having elevated important constitutional questions about the relationship between administrative efficiency and judicial independence. Chief Justice Roberts, in a rare public statement on pending legislation, noted that while judicial accountability matters greatly, the constitutional structure requires that such accountability mechanisms respect the fundamental separation between legislative and judicial functions. Recent congressional debates have highlighted these essential constitutional boundaries. This acknowledgement from the judicial branch itself underscored the significance of Crockett's constitutional analysis. Rather than partisan talking points, she'd articulated constitutional principles that resonated across ideological lines. Perhaps most significantly, the Crockett-Lieu exchange catalyzed a broader national conversation about judicial independence in the modern administrative state. Editorial boards across the country published thoughtful analyses examining the tension between administrative efficiency and constitutional structure. Representative Crockett's questioning exposed a fundamental tension in modern governance, wrote a constitutional scholar in The Atlantic. We cannot simultaneously demand administrative efficiency from courts while preserving their constitutional independence. This is not a partisan question, but a structural one that goes to the heart of our constitutional design. 6 months after the confrontation, its impact continued to resonate. The revised Judicial Evaluation Act that Lieu eventually introduced bore little resemblance to the original legislation. Gone were provisions empowering Congress to evaluate judicial performance or connecting resource allocation to efficiency metrics. Instead, new bill focused on enhanced data collection by the Judicial Conference itself and voluntary best practices developed within the judicial branch. In introducing the revised bill, Lieu explicitly acknowledged Crockett's contribution. This legislation reflects a constitutional approach to judicial improvement that respects separation of powers principles articulated by Representative Crockett and constitutional scholars. Rather than imposing congressional metrics on the courts, it supports the judiciary's own constitutional authority to improve its administrative functions. The revised legislation garnered bipartisan support, with members from both parties recognizing that it respected constitutional boundaries while addressing legitimate concerns about judicial administration. What began as a partisan proposal had evolved into a constitutionally sound approach through the process of substantive debate. For legal scholars, the Crockett-Lieu exchange became a case study in effective constitutional oversight. What made this confrontation historic wasn't partisan scoring of points, explained a professor at Yale Law School. It was Representative Crockett's focus on fundamental constitutional principles, rather than political advantage. She forced a reckoning with the constitutional structure itself, not just the policy merits of the legislation. 3 years later, when a major separation of powers case reached the Supreme Court, multiple justices referenced the revised Judicial Evaluation Act as an example of legislation that properly respected constitutional boundaries between branches. Justice Kagan's majority opinion noted that Congress demonstrated constitutional wisdom in revising earlier proposals to respect the judiciary's internal administrative independence while supporting legitimate efficiency goals. For ordinary citizens, the confrontation offered a rare glimpse of how congressional oversight should function in a constitutional system. A civic education organization developed a teaching module based on the Crockett-Lieu exchange, using it to demonstrate how substantive constitutional debate can transcend partisan division and actually improve legislation. As for the personal impact on both representatives, the confrontation ultimately strengthened their professional relationship. 6 months after the hearing, they jointly sponsored legislation on criminal justice reform that carefully respected constitutional boundaries while advancing shared policy goals. Their collaboration demonstrated that substantive constitutional disagreement properly navigated could lead to more effective governance rather than partisan division. Crockett herself rarely referenced the confrontation in public statements, maintaining her focus on constitutional substance rather than personal vindication. When asked about its impact years later, she offered a characteristic response that emphasized principles over personalities. Constitutional boundaries aren't Republican or Democratic, they're American. My exchange with Congressman Lieu wasn't about winning an argument, but about ensuring that legislation respects the constitutional structure that protects all citizens regardless of political affiliation. The lasting legacy of the confrontation wasn't a political victory for either representative, but a reminder that the most effective oversight comes not from partisan attacks, but from substantive constitutional analysis. In an era often dominated by performative politics, the Crockett-Lieu exchange offered a glimpse of how congressional debate could elevate public understanding of constitutional principles while improving the legislative process itself. If you found this analysis valuable, don't forget to like this video and subscribe to our channel for more in-depth coverage of today's most important constitutional debates. Leave a comment below, sharing your thoughts on judicial independence and congressional oversight in our constitutional